Hi, everyone. I'm Winnie Young, Assistant General Counsel of Microsoft. I'm based in Hong Kong and covering legal support for the Greater China region. It gives me great pleasure to be moderating this next session on technology and sovereignty, and a very warm welcome to all of you from Hong Kong. Before I invite my distinguished panelists to speak to us, allow me to share a few thoughts with you. While internet and new technologies tend to make the world smaller and break down national borders, we see that states are exerting more control or sovereignty over data. States see value in controlling data for national security and law enforcement purposes, as well as economic reasons. Advances in big data analytics and the race for advanced AI capabilities both highlight the value of data. With geopolitical instability and the rising value of data, navigating data sovereignty issue is increasingly challenging for MNCs operating around the world, as well as public cloud service providers like Microsoft. Data sovereignty may take many forms. Some states equate data residency with data sovereignty, and they may even further seek control over cross-border transfers of data, including personal data, as well as sensitive data relating to the country's CII. For example, data in the finance systems or energy industries. Many policymakers might have reflexively and mistakenly believed that data is more private and secure when it is stored within a country's borders. However, in most instances, data localization mandates do not increase commercial privacy or data security. In a recent paper that we did in collaboration with the Australian Financial Review, we make the case that digital sovereignty is not about ensuring that every part of our digital supply chain is located in country. Rather, it is about ensuring that there are competitive choices for governments, businesses, and consumers, while respecting that the state determines that the rules for technology companies to follow within its own digital supply chain. Microsoft supports a rules-based approach that preserves and advances a country's values in the digital and interconnected world we live in, while building on the foundations of an open and competitive market. We think it is important that these rules align to global norms and standards, so businesses operate within a framework that transfers easily to global markets. Adopting internationally harmonized data protection standards to regulate global data streams would both protect consumers and help companies of one country to do business in other countries and with entities globally. So with that, let me turn to our first speaker for this panel, Professor Andrew Woods. Professor Woods is with the University of Arizona College of Law. His teaching and research interests include cybersecurity, the regulation of technology, and international law, both public and private. Today, Professor Woods will talk to us about sovereignty and artificial intelligence. As we know, AI systems typically depend on large data sets of training. So Professor will explore with us the trend towards AI and the related trend towards large data sets and what that might mean for national technology policies. So Professor Woods, are you ready?
I am, yeah. Can you hear me?
Yes, over to you now. Thank you.
Fantastic. Thank you so much. I'm going to share my screen. Can you, someone give me a thumbs up if you can see the screen I'm sharing? Cool. Thank you, Anne. So thank you, Hao Chen and Anupam, for the invitation to be here. It's lovely to see all of you, so many familiar faces or familiar names and black boxes on Zoom. My topic for the day is artificial intelligence and digital sovereignty. And I want to start with some caveats. The first is that this is not a paper that I have written yet. So I'm presenting ideas for a paper that I hope will maybe spur some conversation. Right now, I have a series of questions which I want to explore, a set of hypotheses more than any strong claims. The second caveat is that while I'm happy to see so many familiar faces, I just want to lament again, I guess it's not a caveat, it's a lament that that we can't be in person in Hong Kong. And I am sorely missing the milk tea, the boba with boba, the egg waffles, the dumplings, and the dumplings. So may we all be vaccinated swiftly. So what I thought I would do today is just say a bit about how I came to this project, and then maybe turn to examine two different potential sets of hypotheses that might explain the relationship between AI and digital sovereignty, if there's any relationship at all. I'll start with a motivating question, which is just absurdly large in scope. So at the highest level of generality, I'm wondering what the relationship is between the state and artificial intelligence. Sorry, my screen just went funny. So obviously you could imagine coming at this enormous question from the standpoint of, from a bunch of different standpoints, or with the benefit of different theories. You could approach it from the perspective of democratic theory, or game theory, or string theory. I come at this question from a rather pragmatic place. So let me just say a word about that, and then I'll outline some hypotheses. So in earlier work, current work, I guess, and earlier work, I've been looking at how people have what we might think of as a judgment bias against machines. That is, we're less willing to accept failure from robots, and we regularly opt for less well-performing humans. And this is true in a range of domains. Examples abound in medicine, finance, law, the arts, really anywhere you look. Maybe the simplest example is self-driving cars, where we demand near perfection from the machines that drive us around, but we tolerate incredibly high levels of risk from human drivers. In my own state of Arizona, there are about 1,000 deaths on our roads at the hands of human drivers, most of which are, of course, the cause of the result of human error. But when a single self-driving car was involved in a fatal accident, there was a huge public outcry. The governor made pronouncements, new policy was passed, and the program testing those self-driving cars was shut down. As the director of Toyota's self-driving car program said at the time to Congress, the public has zero tolerance for mistakes from machines. So we see this at the personal level, but we see this at the policymaking level as well. Now, let me be clear. I'm not suggesting that there aren't good reasons to be worried or skeptical of machine decision makers. In particular, I worry about the political economy in which they're created and largely only accountable to private corporations. So anyway, I'm trying to get my head around how we think about risk from machines. And I've got a co-author at BU with whom I am in the middle of conducting an experiment to try to figure out how diverse patient populations in healthcare feel about automation, the rising use of AI in healthcare. So this project got me thinking about the governance of AI in general and different communities' approaches to AI. So that's the background that leads me to today's topic. So what I want to do today here is just quickly explore a few possible avenues for thinking about the relationship between AI and sovereignty. I'm going to start by saying something about defining terms, because as has already been mentioned, sovereignty is an expansive concept, and so is AI. So I want to just acknowledge that generally one should try to define their terms. I think here, one of the most interesting aspects of my little charge in this project, this broader book project, is that the story you could tell about the relationship between AI and sovereignty really changes dramatically depending on what you mean by these terms. For example, if you think that sovereignty is about state control over a territory, and you define AI as big data sets used to train a machine learning algorithm, you get one kind of story. if instead you define sovereignty more expansively along the lines being discussed here yesterday as functional or relational, let's say that you define AI as machines that substitute for human decision makers, you get a very different kind of story. So I'm not terribly interested in defining the terms at the outset, not because I don't think that's an interesting debate to have, but because I don't want to embrace a definition of either term that would narrow the potential range of hypotheses that are worth exploring at the outset. For now, I just want to note that it's interesting and perhaps telling that the relationship between X and Y depends quite a lot on how you define X and how you define Y. And we're dealing with X's and Y's that are hotly debated, expansive concepts that really defy easy and complete definition. Okay, that's a lot of throat clearing. So let me put some hypotheses on the table. And I want to do these in two chunks. One is hypotheses where the causal chain is state does something or has an approach to data policy that leads to changes in AI, and then I'll flip the lens. So one set of hypotheses that merits further inquiry are about how the state and its approach to the digital domain will affect AI's future. For example, we might ask, what is the relationship between China's attitude towards data, in particular where the state is not just aggressive about access, but also aggressive about control and is actively tuning governance based on inputs from data? China is maximalist in this respect. And I wonder, whatever else we might think of it, does this help their AI development? Does being jealous of sovereignty and hungry for data help a state's AI efforts? I suspect it does, but that's an open question. The logic that it does would be something like this. So in the automotive space, Tesla is perceived to have a huge advantage over rivals in machine learning, in their artificial intelligence program, because they have more data than anyone else. So if more data means better AI, then some states will have an advantage in AI, and that will be as a consequence, in part, a consequence of their digital sovereignty stances, in addition to lots of other things. But maybe data hoarding has perverse consequences for AI. Maybe the hypothesis is completely wrong. Maybe actually it encourages over-reliance on the kinds of tools that rely on large data sets and underinvestment in other things. And some self-driving car experts look at Tesla and think that's exactly what's happened there. Yes, they have fantastic artificial intelligence, but they're overconfident in data sets and underinvesting in other areas. So you could imagine, I think, even a 2x2, if I can put this up here, where the state's policy on data governance affects the state's advances in AI, depending on where the development in AI is happening. So if maximal data controls on the state side may reap big gains for states where AI is being developed is a state-led project. But that might not be true in a state where AI is being developed entirely in private hands. I have no idea if this makes any sense, but just a potential framework for thinking about 4 different hypotheses about the relationship between the state's approach to cyberspace or digital sovereignty, I should say, and artificial intelligence. Okay, we could flip this around and ask, how does a state's experience with artificial intelligence affect the state's policy towards digital sovereignty? What does the development of autonomous systems mean for state policy in this space? One possibility is that early and public successes with AI will cause a state to, say, soften their policy towards privacy. We're getting something positive from collecting lots of data, so let's lower the barrier to collecting lots of data. That's one possibility. And it might not just be this state's experience with AI, it might be other states. So you could imagine that states would see another state's success in artificial intelligence and think we need what they have, and enter into essentially an arms race in artificial intelligence which would then lead them to modify their stance towards data controls, maybe knock down privacy protections in the name of something like, you could imagine an AI Manhattan Project, where there's a national charge. There are plenty of folks at the Pentagon who want to do this, a national charge towards developing better, stronger, more robust AI for lots of reasons, but war fighting is one of them. And as a consequence, we need to change the way we approach data, or in particular, the state's approach, the state's control over data. Maybe the arms race goes the other way. Maybe it becomes a disarmament race. If we see another state's terrible failures with artificial intelligence, autonomous weapon programs go on rogue, say, states will say, we need to change the way we approach data because of this thing that's developing. Either way, I suspect we'll see that states' experience with AI will in fact inform how they approach sovereignty in the digital domain. So, oh, sorry, I'm very bad at advancing my slides. Let me just end with a plea. As you can tell, this is incredibly high level, and I'm just embarking on writing this chapter. And so I want to end with a plea, which is that if you have any further thoughts or suggestions for hypotheses you think worth testing, or readings, please send them along. Don't be a stranger. And I look forward to the conversation. Thank you all so much.
Thank you so much, Andrew. Because of the interest of time, we'll do the Q&A at the end of the session after all the other panelists have presented. I hope it's okay with you. And next up, we have our dear friend, Hao Chen. He needs no introduction. He is the reason why we're here today, in fact. So for Hao Chen, he previously served as a director of the Law and Technology Center and the LM program in Technology and Intellectual Property Law at the Faculty of Law in Hong Kong University. He specializes in intellectual property, technology law, and Chinese law. Today, he will be talking to us about intellectual property and AI creations, whether AI creation should be protected by IP law, and the conflicting judicial rulings that we are seeing in the EU, US, as well as China. So please, Hao Chen.
Thank you. Thank you so much, Winnie. I'm trying to find my slide and share them. Oh, files. Really looking for it. Oh, here we go. I think I can. Basic. Oh, here I found it. So as some of you have already mentioned, 2020 was really a bad year. But for AI and IP issues, 2020 is was actually a pretty good year, because in jurisdictions like EU, United States, and China, judges dealt with leading cases concerning IP protection of AI creations. So in today's presentation, I'm gonna quickly review these cases first, and then move on to discuss the takeaways that we can get from these case studies. And then I will consider to what extent digital sovereignty could be an important issue for dealing with the IP protection of artificial intelligence creations. So let me talk about the first two cases that EU judges decided last year. So first of all, this is a case of dealing with a patent that can determine cardiac output with the aid of artificial neural network. So this is a picture depicting the nature of this patent. And the EPO ruled that this invention could not be granted patent because the application itself failed to meet the disclosure requirement. As many of you know, a successful application should sufficiently complete and clear for a patent, application. Enable, for a person skilled in the art to carry out the invention. But EPO found out the artificial neural networks are composed of layers upon layers of interconnected variables, so just variables. So it's virtually impossible to trace the output of the neural network. So it failed to sufficiently disclose, technical information. And EPO also ruled that this, application also failed to meet another patentability requirement, namely inventive step, because this application does not, provide, enough details about how the training of neural network took place, and that means that reasonable people skilled in the art, could, it's obvious to people skilled in the art. So the second case, let me move on to the second case. The second case, the EPO decided against granting patent protection to AI creation, concerned the so-called Davos system. So Davos system employs a set of artificial neural networks to generate new ideas before a subsequent set of neural networks analyze them to determine whether they are novel, useful. And in the application, the applicant designates Davos as the inventor. So this is a application that treats artificial intelligence itself as the inventor. So EPO decided that an AI system could not be designated as an inventor on a patent application. According to the decision, an inventor must be a natural or legal person. This is required by EU patent law. So the law requires that the designation must state the family name, given name, and full address of the inventor. So names for natural or legal persons are not merely for identification purposes, but form part of their personality and allow inventors to exercise various rights. As you know, patent law grants a bundle of patent rights to patentees, ranging from the right to use to the right to sell. Okay, so this is the extra meaning of designating natural or legal person as inventors. So let me move on to the US case. So this Davos patent was, Davos invention was also filed for, filed to the US trademark, Patent and Trademark Office on the same basis for designating Davos itself as the inventor. So the USPTO made a similar ruling on the basis of US law, arguing that under US law, only a natural person or a legal person can be deemed an inventor. So the statutory language is pretty clear. As I highlighted, it's all about, for example, the individual, whoever, him or herself, a person. So the statutory language is, very clear, saying that an inventor under US law must be a natural or a legal person, okay? So let's move on to the Chinese cases. Chinese courts decided on very interesting cases concerning AI creations. So in the first case, this case involved Tencent. So Tencent, came up with a computer program. It's artificial intelligence-based computer program called Dream Rider. So the DreamWriter each year produces around 300,000 articles, and regarding this case, DreamWriter produced an article on Financial News, and the defendant republished it on its website without Tencent's permission. So Tencent sued the defendant for infringing copyright. The Chinese court ruled that the first issue the Chinese court decided on was whether this AI created work was copyrightable or not. So first of all, it applies the originality requirement on the Chinese copyright law. Originality has two components. It's it's same with the U.S. American Feist decision. Okay, first of all, a work should be independently created, and secondly, it should have a minimal degree of creativity. So the court ruled that the article was obviously independently created by the Tencent team through using DreamWriter. And with regard to the minimal degree of creativity, the court rules that the article reflects the selection, analysis, and judgment of the relevant stock market information and data on the relevant earning. So this article has a reasonable and expressive structure and a clear logic. Therefore, it meets the minimal degree of creativity requirements. So the article itself is original. And then the court moved on to discuss the implication of human contribution to this copyrightability issue. According to the court, human contribution actually is one of the key issues for deciding whether the work itself is copyrightable. According to the court, the process of creating the article involved the creator's personalized choice, judgment, and skills. The automatic operation of the DreamWriter software is not entirely independent itself. Actually, its automatic operation reflects Tencent team's choices and is also determined by the characteristics of DreamWriters. So this human contribution is obvious, and then the court ruled that Tencent should be deemed the copyright owner of the article. So thereby, the defendant was held liable for infringing the copyright. The second case the Chinese court decided involved a really landmark battle between a Chinese artificial intelligence company called Zhichen and Apple. So the Chinese company developed a patent. It's actually a chat robot system called Xiaoai Robot. So the company filed for patent protection in 2004, and then the application was approved in 2009. And then the Chinese company decided to sue Apple, alleging that Apple's voice recognition technology Siri had infringed its patent. So in response, Apple sought to challenge the validity of the Xiaoai patent, this chat robot patent. Argued that the Xiaoai patent failed to meet the patentability requirements, such as enablement, written discrimination, and novelty and inventiveness under Chinese law. And the Chinese court invalidated the Xiaoai patent on the grounds that the patentee failed to sufficiently disclose the gain function feature that Xiaoai robot offers. But this actually is a legal case that went directly up to the Supreme Court. And in June 2020, the Supreme Court overturned the lower court's ruling, holding that chatbot patent was valid. According to the court, the disclosure requirements actually applied differently for non-essential technical features common in existing art and distinguished essential technical features. So for non-essential technical feature, the disclosure requirements are lower. And the court found that the gain function feature of the Xiaoai patent is actually a non-essential technical feature common with the existing art. And so therefore it was subject to the less stringent requirements. Therefore, the patentee actually has met the disclosure requirement, and the patent was held valid. And so let me move on to talk about the takeaways that we can get from the cases. So first, the Tencent case that I discussed earlier actually has cleared the clouds on how AI generated work or AI creations should be copyrightable or not. So how shall we discuss this issue? At least under the Chinese copyright law, I think the Tencent ruling sheds light on this issue. First of all, we need to think about whether work itself is original or not. And then secondly, human contribution, the existing human contribution to decide this issue. And there is human contribution and the work itself is original, then the ownership of the work actually goes to a natural or a legal person involved. And with regard to the AI emissions and whether they are patentable or not, EU actually has adopted stringent disclosure requirements. And then China, as we can learn from the Xiaoai case, has adopted less stringent disclosure requirement. In China, it seems China is more willing to accommodate the black box nature of AI in the patent applications and accept inventions which rely on AI to produce an outcome. So let me move on to deal with some forward-looking issues that we can learn from these cases. And so first of all, I think we can think about how we can provide IP protection to AI creations with human contribution. So as you see that, for example, the work created by the screenwriter, okay, so it involves human contribution, right? Okay, so I think with respect to this issue, IP protection standards could be wide-ranging. We can draw on existing IP standards, such as originality, to decide, and as the Tencent case has demonstrated. And I think it's a worthwhile perspective we can think of is to actually create a sui generis system. As you know, these AI creations actually, even though the AI creates something, but it draws on actually existing data and to a certain extent public domain information. So then there's a big question whether we need to give full copyright protection to such work. Maybe a plausible way is to, for example, to provide a lesser term of protection, for example, just 15 years. And data sovereignty actually kicks in because I think to a certain extent, this is not only just a national legal issue. As Professor Mark Hu has mentioned, data actually flow across borders. And so now we have to think about how we can deal with data governance in a global setting. So then there's a question about how we should come up with new international law to govern this issue. And international organizations, shall we choose WIPO, the World Intellectual Property Organization, or WTO? And WIPO actually has started dealing with this issue, and it has created the Conversation on IP and AI program. And so this is a multi-stakeholder forum for WIPO members. and it aims to understand the impact of AI creations on the existing human-centered IP framework. Yeah, 3 sessions have been held since 2019, and WIPO also has created an AI and strategy clearinghouse database. So this database has collected a lot of judicial rulings, policy papers, and reports issued by WIPO member states. And another major issues that is arising is about how we can protect autonomous AI creations without always very limited human contribution. So as many of you know, through machine learning, autonomous AI can now create without direct human influence. After initial human input at the programming stage, the AI evolves in subsequent training cycles during which the structure of the algorithm changes by itself. The greater the evolution, the smaller the remaining human connection to the creative process of autonomous AI. So, for example, now we have something called creative autonomous robots, such as Auron and the Painting Fool. And the next Rembrandt project also is another good example of autonomous AI. So how shall we deal with IP protection of autonomous AI creations? Again, we have a few choices on the table. We can rely on traditional IP protection standards such as originality, patentability, or we can come up with a sui generis system. But I am quite optimistic about the public domain system. My suggestion is that we should probably leave AI creations in the public domain free for everybody to use and without IP protection. One of the reasons is that this autonomous AI creation system actually heavily draws on existing data. And so it already has very strong connection with the public domain. And second reason is that there's still a very big question mark whether autonomous AI should be legally recognized under current IP law or even under the sui generis system. So whether it is could be recognized as equal to human beings. So there's a very big question mark there. So if we have such doubt, then why don't we put it in those creations in the public domain first? Then there comes the data sovereignty issue. Similarly, I think we should ask whether this issue should solely be addressed by domestic legislature or courts. But this is not that likely because, as I mentioned earlier, this is a global age. We need to think about international law and how global governance should be reshaped to deal with this issue. And again, I think WIPO or WTO may play a big role, but maybe I think I want to propose a thought experiment. Maybe it's time for us to think about creating a new international organization that deals solely with AI issues. So, for example, international organizations, something called International Organizations on AI. And if autonomous AI develops fast, maybe it's the AI itself can create a new international organization by itself. And then it will pick its own organization to deal with its own creations. So that's a really, future-looking perspective. So I think, when it comes to digital sovereignty, we have, these, institutions involved, and some of them will be new and futuristic as well. So this is my talk. Thank you very much.
Thank you, Hao-Chin. Those are very intriguing questions about how to protect AI creations and really, new questions and food for thoughts. Next up, last but not least, for our panel today, we have Professor Ann Cheung, another good friend from the University of Hong Kong, Faculty of Law. Ann is a professor of law and co-director of the Law and Technology Center. Her research interests include freedom of expression and privacy, focusing on the challenges brought by the internet and technology. And today, she will be talking to us about a slightly different concept of sovereignty, which is self-sovereignty, the idea of individuals retaining control over their personal data, and how this self-sovereignty is challenged by the pandemic that we are all living in right now. So, handing over this to Anne.
Hi, thank you, Winnie. So good morning and good evening. I will talk about this topic very close to our heart, not as fascinating as what Andrew and Houghton has been talking about AI. So is the pandemic, COVID-19. We have been fighting, coping, and living with COVID-19 for almost a year by now. As of today, according to the statistics of WHO, that we have more than 85 million confirmed cases and nearly 1.9 million people have died of it, affecting 222 countries worldwide. In the fight against this pandemic, many governments have been taking unprecedented measures to track, trace, and contain the spread of the coronavirus, involving the use of innovative data-driven technologies. And we have been keenly following the spread of the coronavirus. For instance, in Hong Kong, we have been doing that too. The government has this special dashboard enabling us to see the spread of the coronavirus. It's not only detecting the spread of the coronavirus, we are able to see the individuals, namely that we will know the age, the gender, the nationality, and the residential building that this person is living in. And it also enables us actually to see the neighborhood that this person has moved around. That in this type of technology that includes massive collection and sharing of data, and we do it in the name of controlling the coronavirus and in the name of public health. In this debate of fighting against coronavirus with sacrificing our public health, sacrificing our data privacy, many of us ask whether this is a worthwhile trade-off. And in this fight, we have been using a lot of technologies, which has been playing a very powerful role in the attempt to control this spread. And they are making significant contribution. But in the use of this technology, very often we need to sacrifice our data. For example, that in the use of contact tracing apps, that detailed and frequent location data that can lead to inferences about the private social life of us and our health status will be collected and shared. Our social interaction enable the reconstruction of our social graph about where, when, and whom we have met. So the question is this trade-off necessary? In normal times, we will see this as highly invasive tools. But in this time of public health emergency, that we are leveraging personal data as containment effort, not only to contain the spread of data, but also to predict travel patterns, pinpoint future outbreak hotspots, model chains of infection, and project immunity. But widespread data sharing, monitoring, and surveillance could easily become fixtures of modern public life. The fear is that these temporary measures may become normalized and set dangerous precedent. We have been talking about data sovereignty for yesterday and today. So the ultimate question is who has this power to control? We look at power, data, and privacy and examine ways in which they may be intensified in this context of COVID-19. Data sovereignty, as we have discussed, is said to be a very broad concept, which covers the control of an individual's personal data and identity. Sovereignty was largely centralized or thought to be centralized by the state until we move into the digital age when large international tech giants began to increase their stewardship of our personal data. In this new data spectrum that emerges, we find not only the centralized state, but also cooperation and increasing alliance between state and corporation. In contrast, the self becomes small and vulnerable. The question still remains, who can exercise control on what and for what purpose? And the question I would like to explore is how to protect privacy in this changing relationship between actors, data, and infrastructure in this time of health emergency. So I will start with looking at the role of the central state, looking at an example of South Korea. Although South Korea has faced the third wave of coronavirus at the end of last year, the cases and deaths remain relatively low compared to other parts of the world. That initially, it had the largest number of confirmed cases outside China, but new cases dropped sharply. And South Korea is praised highly for its proactive testing and tracing efforts. And let's see what they had done and what type of data that the government can collect and share. So according to this graph, that the Korean Centers for Disease Control and Prevention under the Ministry of Health could collect and share 7 categories of personal data, including location data, credit card transactions, and transit pass records in the time of COVID-19. And they will share this type of data to central, local, and municipal government, to the Ministry of Health and Welfare, to police, and to National Health Insurance Authority. In addition, the center must also promptly make publicly available certain information on the internet, namely the path and means of transportation of infected persons, the medical institutions that infected persons have been treated, their health status, sex, nationality, and age of infected persons, though the actual names of individuals will not be disclosed. And sometimes highly detailed routes, including names of shops and restaurants, will also be disclosed. The location of infected individuals often attract extensive news coverage. So seemingly, the virus is contained, but there is a price to pay. So in this story, what I reported, including by the New York Times, is about Mr. Kim and Ms. Kim. They are not related, and actually each of them had their individual engaged partners. But both of them were tested positive of COVID-19. So their information, including an age, gender, and recent whereabouts, were being disclosed on the internet, including showing that both of them had visited a beachside hotel on the same afternoon, on the same day. And netizens quickly concluded that they had been unfaithful to their partners and started to harass them, condemn them, and triggered a series of doxing activities. But in fact, it was revealed that both of them were actually attending a workshop by the church in that particular hotel on that particular day. So this was the case of the role of the central state. Then the second scenario that I'm going to look at is the growing alliance between state and corporations in 3 particular areas. So the first is about telecom company. That it was reported that at least 27 countries are using data from telecom company to track movement of citizens in aiding government to monitor and enforce social distancing. This happened in Switzerland, Austria, UK, Italy, and Germany. All these companies defended, saying that they had only provided anonymized movement flows data of its user to authorities and to alert the authorities of gathering of crowds. In the second example, the use of technology is state and contact tracing apps. Countries around the world have developed and deployed contact tracing software on mobile apps. So they are in general categorized by whether it is based on GPS or Bluetooth and whether it is using a centralized or decentralized system. So when Google and Apple together introduced this API platform for other developers to use, it was applauded, seeing that as a major move to protect personal data privacy. But even that, the authorities, for example, the French government requested Google and Apple to facilitate centralized processing. And luckily, Google and Apple said no to this attempt. But other countries, including UK and Switzerland, and some of the states in the US, had used decentralized frameworks developed by Google and Apple. As Google and Apple are providers of the operating systems, they have access to all the data that runs over their interfaces. The companies also claimed that they only used anonymized data. The third example is about symptom reporting and tracking. So Verily, a subsidiary of Google, is developing a baseline testing for COVID-19 with various state governments. What Verily provides is a digital platform where people can be screened for their symptoms, schedule testing appointments at participating sites, and check back for test results. The individuals have to submit very detailed personal data, including health data and their history. When individuals find that before one can use this platform, they have to register with their Google account. That this raises fear that this will only enable further data harvesting and sharing with Google. And this project is stopped in the state of San Francisco. So in looking at all these examples, we ask these fundamental questions: who should have power to control? In the framework of traditional human rights discourse, we know that human rights, including privacy, is not absolute, but restrictions on human rights should be prescribed by law, should only be done if it is necessary and the means are proportionate. In addition to human rights discourse, we know that the personal data regime of the 7 established principles, that the collection, disclosure, use of data should fulfill certain fundamental principles, including limitation, data minimization, and accountability. But the challenges to privacy control in this time of pandemic is largely at 2 levels. One is doctrinal, is that its current legal framework, has it provide sufficient protection and providing the right balance? We know that traditional human rights framework can only hold the state to be accountable, but not corporations. And in terms of actual implementation, though we have those 7 established personal data principles, but there are still fundamental questions that we are not sure how to address in this time of pandemic. Namely, what data have been collected, whom is it shared with, when data will be deleted, how information will be used, and who can oversee the above. Namely, on this fundamental question about what type of data is being collected, we know that personal data law only protects personal data, but that in examples that we have looked at, that the companies often say that they only use aggregate data or anonymized data. We know that a variety of types of information has been collected during this COVID-19 pandemic. Depending on data type, the approaches and measures taken to mitigate privacy concerns will be very different. And there are different levels of anonymity, which we are not sure about. And it is very common to find in contractual terms saying that retention period will be no more than necessary. But we're not sure what no more than necessary mean. and how are we going to enforce it? So I would suggest of this framework that we need a new type of infrastructure to manage our data sovereignty. The first is that we need a new legal framework that can hold both the state and corporation accountable. The focus should be on anonymity control and transparency, and about this concept of oversight. The second is that we need to have effective independent statutory watchdogs that has the actual bite. For example, we mentioned the extensive collection and disclosure of personal data in Korea. But the South Korean National Human Rights Commission condemned this practice and said that this detailed information was unwarranted to be disclosed. And after that stance, the Korean government has also modified the practice that right now, the government no longer reveals a patient's age, sex, nationality, or workplace. And that information put up on the internet for public viewing will be deleted after 2 weeks. In another example about the Dutch Data Protection Authority, that it recommended against a bill allowing government to force telecom company to collect and share data as part of the country's pandemic response. The third is about the role of civil society that can play. That very often that individuals may not have the resource to be technocrats and to guard against or to watch about the company's practice. So in this particular company called GuardSquare, which is a security firm, that it has issued a special report in examining different contact tracing apps introduced by different governments. In its June report, it has examined 17 contact tracing apps by different governments, and according to its criteria, then none of them had satisfied the security measurements. And in its latest report, it has examined more than 90 contact tracing apps. To conclude, in this debate about weighing public health and privacy, we know that the individual is small and vulnerable. But at the same time, when we are so eager to protect our public health or our life, we need to be aware that COVID-19 or all these technological devices should not be function as a Trojan horse in encouraging people to accept intrusive surveillance in the name of public health and safety, and to normalize oppressive surveillance measures. Tracing disease should not end up to be tracking of individuals, and surveillance should not end up in a culture of self-surrendering of data. So the solutions that I have suggested is that we also need to hold corporations accountable because they have functioned like a quasi-public authority, or what we have been discussing, that they have been exercising functional sovereignty. And we need specific measures to exercise anonymity control, transparency, and oversight. So I welcome any questions in our discussion. Thank you.
Thank you so much, Anne. So with that, we have heard from all our panelists for this session. And I note that, we have just gone slightly over. We do have one question posted in the Q&A box, and it's a question for Ho Chen. It's about AI and IP. And the question goes like, should AI inventions be protected by IP regulations as long as any subtle or unique human input can be recognized? And if IP's the main aim is to incentivize innovation balanced with public welfare, is a sui generis approach more balanced?
Hello.
Ho Chen?
Sure. This is not only one question, there are multiple questions. So I think I'll just pick one and leave some time for other speakers. I think probably Winnie has questions. I think, in my opinion, the sui generis approach will strike a better balance, between private interest and public interest, because in my understanding, AI creations no matter whether they are, totally autonomous or with the involvement of human contribution, still draws largely on public domain information. So the question is, so we give so much IP protection, or the conventional IP type of IP protection to this new works or inventions. So I think a sui generis system with, for example, with shorter duration of copyright protection and limited scope of patent rights would serve the public interest better. But as it is a sui generis protection, right? So it still protects rights holders' interests, so it can still play the role of incentivizing, and for example, protecting certain kind of personality and dignity. So yeah, I go for a sui generis system.
Okay, thank you, Hao-Chin. I do have a quick question for Anne. So, it's a fascinating discussion that you have about, the self-sovereignty and how you balance that against, such a, critical situation that, we are facing now during the pandemic. So the kind of solutions that you're proposing, Anne, do you see that whether that's sufficient with the current infrastructure and system that we have already, or are you proposing that we really have to step up on, what we already have in the system, or we need a new sort of enforcement or watchdog organization to ensure that our privacy will be protected?
It depends. Like if we were talking about Hong Kong, that I think we need to step up this, because our privacy commissioner, that I don't think that it has, the commission does not have enough power to do it. And very often the monitoring work, that very often what we hear in a debate is that public health is too important and that privacy is not absolute. So this is the common rhetoric that we have been hearing in Hong Kong. And then that's why I said that for the watchdog body that we should have in the society should have actual power, like in the Hong Kong system, that because we know very little about how commissioner is being selected and appointed. That is not a tenure system. They have the limitations. Our personal data privacy law is also very outdated. So does not cover the regulation of aggregate data or pseudonymized data or anonymized data. So there are certain limitations that in the Hong Kong system.
Right. Well, thank you, Anne. Give us a lot to think about, how to improve our privacy protection here in Hong Kong. So with that, I think we will close this panel. And should I hand it over to you, Hao-Chin, or to the MC?
Yeah, I think we can. Let me ask Anupam. We're going to have a break, and how do you think? When shall we come back?
So I'm thinking that we may just want to proceed. Should we take a 5-minute break? I think we should take a 5-minute break and begin at 9:50 a.m. Eastern time. And so let's take a little break.
Okay, great. See you later.
Okay, thanks. See you guys later.
Thank you so much, Winnie.
Thank you all.